Testing 1 2 3. Testing 1 2 3.
It was just that I had to switch mine and switch my receiver to mine because it comes into this thing. But also, there's these white tiles on the ceiling, those are actually scratched. So you're kind of in between two of them. Just curious. If you want to go like a live ambient sound or something like that, it's just a feature like.
It's okay.
Let's come back here until everyone's sitting.
Okay. Y'all ready? Where's Ed? Where'd Ed go? Chelsea, y'all ready? Okay. Good afternoon. Welcome to the Titusville Code Enforcement Board. Please silence all your cell phones. The city desires to accommodate persons with disabilities. Accordingly, any physically handicapped person pursuant to Chapter 286.26 of the Florida statute should at least 48 hours prior to the meeting submit a written request to the chairperson that the physically handicapped person desires to attend the meeting. Any person who decides to appeal any decision of the Code Enforcement Board with respect to any matter considered at this meeting will need a record of the proceedings, and for such purpose may need to ensure that a verbatim record of proceedings is made, which record includes the testimony and evidence upon which the appeal is to be based. Any person or defendant who requests to review or object to any exhibits presented to the Code Enforcement Board by the City of Titusville prior to submission to the Code Enforcement Board must stand and state their request to review the exhibits prior to review by the Board at the time their case or agenda items comes before the Board for hearing. Any person found to be in violation of the City of Titusville Code of Ordinances and given a time frame in which to comply shall, upon compliance, be responsible for contacting the Code Enforcement Supervisor for an inspection to verify said compliance. The violation will not be considered to be in compliance until the Code Enforcement Supervisor is notified and verifies compliance. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And we do have a quorum present. Deborah, can you swear in the witnesses, please? Or the staff?
Please raise your right hand if you plan to testify. Anyone who plans to testify, please raise your right hand. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth?
I do.
Everybody had a chance to read the minutes from last month?
I move to approve the minutes from last month.
A second?
Second.
Ashley, no, but I forgot what I was gonna say. Ashley, oh crap, what did I say here? Ashley made a motion to approve the minutes for last meeting, seconded by RL. Any questions or concerns? Roll call vote, please.
Member Edens,
Yes.
Vice Chairman Beckles,
Yes.
Member Grant,
Yes.
Member Monis,
Yes.
Chairman Bell.
Yes. Motion approved. Chelsea, would you like to start, please, ma'am? You're not on the mic?
Regarding case 19-28, Jeffrey Daniels and Pasquale Daniels, they are my neighbors directly across the street from me. I haven't had any social or neighborly contact with them in over 7 years. I do not have any contact of any part of this meeting, and I have no problem with sitting on this. I just want to make the board and you make aware of it, okay?
Thank you. Did you discuss this matter with the code board attorney?
Yes, ma'am.
Okay, thank you very much. The first case listed on your agenda for today's meeting is case number 19-21 for the property located at 4110 Barna Avenue. For this property, the city has found compliance and the city wishes to withdraw this matter. No action is needed. The same result has been achieved for case number 19-22 for the property located at 4170 Barna Avenue. The city has found that MJ Holdings 2001 LLC has achieved compliance and the city wishes to withdraw this matter. The next case on your agenda is number 19-28 for the property located at 1340 Santa Cruz Avenue. I'd like to invite Officer Tuggle to the podium to present testimony for this matter. Would you like to begin with the PowerPoint?
First, I'm going to submit the...
Okay.
Before I start with the PowerPoint, I'd like to submit a copy of the PowerPoint, the affidavit for the notice of violation, and the affidavit for the notice of hearing and complaint, along with the cost recovery statement into evidence as exhibits 1 through 4.
Can you put your microphone on?
Exhibit 1 is affidavit.
Yes, will be the affidavit of violation, and 2 will be the notice of hearing and complaint. 3 will be the cost recovery. Do we have a copy of the PowerPoint?
I don't.
Okay, I will not be submitting a copy of the PowerPoint into evidence.
Well, it's part of the record anyway.
All right, let's begin with the PowerPoint.
City of Titusville, Florida Code Enforcement Board, case number 19-28. The respondents are Jeffrey Daniel and Pascal Daniel. The violation address is 1340 Santa Cruz Avenue. The notice of hearing and notice of complaint, and notice of violation were mailed to that address, 1340 Santa Cruz Avenue. The violation is Section 28-9, short-term rental of single-family dwellings. Code enforcement originally got the complaint from an anonymous neighbor, and then through research, we found that the property was listed on Airbnb.com, renting out 3 bedrooms and a single-family detached dwelling. The initial inspection was on 4/6 of 2019, and that's when I posted the property. And that date is not correct. It's actually 4/16, not 4/6. The notice was mailed to the respondents on 4/17 by certified mail. It was returned, signed for by J.D. Daniel on 4/29. The notice of hearing was posted at City Hall and on the property on 5/31 of 2019. That date is not correct in there. I apologize for that. The date they were given to comply was 5/6 of 2019. The only contact that I personally have had with the owner was on the first day of inspection. I conducted follow-up inspections on 4/16, 5/6, and 6/10. The results of the inspections are that the property is still in violation as it's still listed on Airbnb.com. Section 28-9, short-term rentals of single-family dwellings, says it shall be unlawful for the owner of a single-family detached dwelling to rent or lease the dwelling to another person for a period of 3 months or less, or to lease or rent the subject dwelling more than 4 times in a 12-month period.
At this time, I'd like to submit into evidence Composite Exhibit 4, which is a copy of the Code Section 28-9, which you're reviewing on the PowerPoint, as well as Ordinance Number 46-2007, the enacting ordinance that created this code.
Chelsea, quick question. Was this enacted before 2011?
Yes, ma'am, it was in 2007.
Thank you.
The following slide is a presentation of the rules that are posted on the Airbnb website. The item that I just passed down the line to the board attorney is a copy of the city's code, which says that it's unlawful for the owner of a single-family house to rent or lease the dwelling to another person for a period of 3 months or less, or to lease or rent the dwelling for more than 4 times in a 12-month period. And if I go to the Airbnb website, I want to know what their policies are for allowing users to engage on that website and rent out their home to users that may decide to rent their space. And it says clearly on the Airbnb website that certain types of short-term bookings may be prohibited altogether. Penalties may include fines or other enforcement. So the host, Airbnb, does let its users know that there may be potential legal implications if you violate local city codes. So we're here today because the City of Titusville's code, Section 28-9, prohibits short-term rentals. You can rent your house out for longer than 3 months, and you can do it up to 4 times per year. But if you exceed that threshold, then the City of Titusville is going to find you in violation of this particular code. So I put this up here so you know that Airbnb does try to educate the users that there are local enforcement that may be above and beyond what the Airbnb policy is. You may go ahead. This slide was added today because the city finds that there's a newspaper article regarding this particular case. And I previously submitted into evidence, we'll mark this as number 5, the article that you see a direct quote from on the presentation. And if you could please pass down the copied sheet. The board attorney has authenticated the article that was published in today's paper. And on the second sheet, you'll see that it's photocopied. You can each have a copy. There's one line that's highlighted.
Has respondent received a copy?
In this newspaper article, there's a quote that I've highlighted and added to the presentation that he and his wife, he being Mr. Daniel, the owner of the property, he and his wife rented out 3 rooms and hosted Airbnb guests for 38 nights over the past year. I find that to be a direct violation of the city's code, which says that you cannot rent your place out for more than 4 times in a year. The respondent has the opportunity to come and speak to you and to answer the question of whether or not he has engaged in this activity. The question here today is whether or not the owner of the property has rented out his home, his dwelling, for more than 4 times within the past year. And if you find that to be the case, then you should enter an order saying so and that he's prohibited to continue that activity for the next year. At this point, each of you should have a copy of this article, and that should be entered into evidence. I believe it's exhibit number 5.
This is the original listing on the Airbnb website, and they were labeled, each bedroom was labeled Santa Cruz bedroom 1, bedroom 2, bedroom 3. There is now a new list. That original listing was removed from the website. There's now a new listing that's in French, but they use the same pictures, and when it shows on the map where the property is, it's the same location. This is the new listing. This is where you can book your dates. There is no perimeter set for how long you can book or how short. This is the map that shows where the house is, and it's right there in the Shangri-La subdivision. This is where I posted for hearing. And this is the Airbnb website as of this morning. The listing is still there. Recommendation. Based on the testimony and evidence presented in 1928 Titusville Code Enforcement Board, it is determined that the respondent, Jeffrey Daniel and Pascal Daniel, are the owners of the record property located at 1340 Santa Cruz Avenue, located in Titusville, Florida, as determined by the property appraiser records, in possession or control of the property, and in violation of Titusville City of Ordinance, Section 28-9 as defined. It's further recommended that the Code Enforcement Board order the respondents to correct the violation on or before 7/8 of 2019. In order to correct the violation, the respondent must cease all rental activity and advertisements for 1 year. The owner is prohibited from offering or entering into any lease agreement with a term of 3 months or less. Order the respondents to be assessed the administrative cost in the amount of $134.21. If the respondent does not comply, by 6/14 of 2019, a fine of $100 per day per violation should be imposed for each day the violation continues.
Any questions?
I have questions for the city. The 2011 statute says that cities are not able to regulate vacation rentals. Do you have a position on that? Are you working on, should our code reflect the same thing as our state legislature?
The enabling was done in 2007, which is prior to 2011, which was exempted. So the code stands.
Our code was written first.
Yes.
But now that the state has passed down a new perspective,
Our
is it
code remains
an
valid.
obligation for the city to adopt a state perspective?
In 2011, when the state legislature enacted that policy, they grandfathered in all of the existing municipal codes. And so the city we are essentially prohibited from changing it unless we want to give up that restriction. There are certain, as I quoted the Airbnb policy, there are many places where Airbnb is activity for short-term rentals, not Airbnb, but any short-term rental activity is prohibited within residential districts. And that brings me to my next point, which is the legislative findings from that 2007 ordinance that the city council found many years before the state made that grandfathering clause. The city council finds that the rental of dwellings or other structures for short-term use by visitors and transients is a commercial activity and is inconsistent with the use of zoning districts devoted to non-transient residential use. Owners that rent or lease for consideration any living quarters or accommodations in any rooming house are exercising a privilege subject to tourist and transient development taxation. Commercial use of single-family residential properties for such purposes as vacation rentals creates an unmitigatable adverse impact on surrounding residential uses. They go on to say many other reasons why the city should not have short-term rentals. And then they say that the city council had a difficult time with it, but they set the bright line distinction between long-term tenancy and short-term tenancy as 3 months.
So this city has, at least at this point, no intention of changing our code.
That's correct.
Say again what you said about the 2011 state ordinance and how it affected the cities and what the caveat was on there.
There are many cities throughout the state of Florida that have been grandfathered into this 2011 legislation, which says that basically we can't change our short-term rental ordinance because we were grandfathered. If we change it, then we would lose the status that we created by enacting this home rule power that we had up until 2011. For as many years as I've been an attorney, the state legislature is trying to infringe on home rule and taking away cities' rights and making laws that say you can only do this on a statewide basis. And the city has vehemently opposed such legislation because it takes away the power of cities to rule themselves.
But it wouldn't just affect the Airbnb, it would affect any.
Right, it's not
Okay.
Airbnb specific, it's 3
Okay.
months or less specific. It's specifically the length of time you have someone coming into your neighborhood where you're not supposed to have commercial activity because the impact it has on the neighborhood.
Okay. Any questions? Ashley or Chelsea?
And so this discussion is most likely going to come down to a city council meeting.
I don't know if the city council wanted to bring it up as an issue. I don't know how else it would become an issue. It's difficult to prosecute these cases, I would say, but I think that the evidence is very clear with this particular case where the owners have expressly stated how many times they've rented their rooms out. They're here behind me and you can ask them that question under oath. How many times have you rented your room out in the past year? And then based on that information, make your determination.
And they still have the ad running even though it's in a different language?
That's correct.
And I got the impression that the statewide legislation was broadening our,
There's continuous efforts by the Airbnb type commercial activity communities to change the state law. But at this time, every year it comes up, and it has not changed at this time. It continues to be a legislative priority for the hoteliers to prevent it because it takes away from their business. And I think that's the main reason why it hasn't created a new law is because of the hotels. But this is all my, legislative opinion that has nothing to do with the case here today. So I could talk about that, but I'll turn it over to the respondent unless you have any other questions for me. Thank you.
Okay. Mr. Pascali, do you wish to address the board?
Yes, I would. To start off, I didn't understand, is your board member, Mr. Monis, he is not voting on this issue?
Correct.
Has he removed himself?
No.
Correct?
No, he's not voting. Yes, he's voting. He doesn't have any conflict of interest.
Oh, I wish to dispute that fact, ma'am.
Well, I'm not into that right now. Let's have your statement, what you want to tell
Can we
the
get
code
your
board.
name and address on?
My name is Jeffrey Daniel. I live at 1340 Santa Cruz Avenue, property in question. And before I wish to start, I insist upon calling for Mr. Monis's removal from this case. He has a long history of animosity and hostility towards us. And just 2 weeks ago on May 24th, he publicly cursed my wife, yelled a profanity across the cul-de-sac at her. This is a criminal offense for which we're considering bringing criminal charges against him. And there's no possible way he could sit in impartiality. He's a biased person in this matter. And I call upon the board that he not be allowed to have any opinion. And I'll leave it to the rest of you.
I've talked to Mr. Moniz. I did not feel that he had a direct conflict. However, it will be up to you, sir. If you feel like you should abstain, we would still have a quorum if you abstained. It would make for a cleaner record if you wanted to abstain and not have that issue hanging over the city.
I have no problem with
A microphone.
Daniel's
Microphone.
proposed I have no problem accepting Mr. Daniels' proposal of not voting on this case at all. As I had expressed to you before, in which way the city wanted me to go with it because of the closeness of the two properties. So I will abstain from voting on this case, and I'll make out the necessary paperwork if you give it to me.
Okay.
Accepted, thank you. I have a statement.
Yes, sir.
I want to say on record that the city's actions in this case are legally flawed and they're disingenuous as well. Statute 28.9 regarding short-term rentals clearly prohibits the rentals of entire dwellings only, and makes no specific reference to single spaces or rooms within a dwelling. The city attorney has taken literary license with this statute. Legal definitions of the word dwelling define it as the entire structure, including all outbuildings and sheds within the curtilage of that property. Please refer to item 2. If I may pass these across to you.
Start down there, sir, with the attorney.
There are copies for everybody, but there's 3 different documents. Please feel free to pass them on.
Okay, just let me get this for the record here. You've got 3 packets. This one's not labeled. Is this what you mean as number 1?
Yes, that's 1, and the other 2, the
This
others are
is
2
a
and 2.
statement from Laureen Jones.
Correct.
Okay, do you wish to put that into evidence?
I do,
Okay, let me let the city attorney have a copy.
of course.
That's number 1. This is number 2.
Assume that one.
This is number 3. Sir, and if you don't mind, when you reference one of these exhibits, just go ahead and state if you're talking about item 1, 2, or 3.
Okay. I may continue, you mean? Item 2, which I guess you'll all have a copy of in a minute, is Titusville's own zoning district standards. It's the guidelines from which city ordinances are derived. In the Titusville zoning district standards, it clearly defines a dwelling as the sum of total square feet of that building. Different size square feet apply to different zoning classifications, but the universal method for determining a dwelling is the overall square footage. And again, I assert the point that your law, you're attempting to read into it more than it says. It says you may not rent the entire rent the dwelling, and I'm saying that the legal definition of a dwelling is the entire building, the dwelling. And the law, in other words, does not specifically address hosted room rentals. Second point I'd just like to make on record is that Titusville has implied consent of Airbnb practice by their willing acceptance and enjoyment of the nearly $1 million in room tax revenue enjoyed by all of Brevard County, including Titusville, provided directly from the Brevard County Airbnb agreement, which has been in place since 2016. That $1 million, nearly $1 million, was just for last year alone. I find it to be duplicitous and hypocritical for Titusville to cherry-pick this beneficial agreement by taking and enjoying substantial tax gains, but yet trying to outlaw the actual practice of Airbnb within their town at the same time. The real issue here should be correcting the city's focus on short-term rentals. Just as Statute 28.9 clearly reads, Titusville needs to limit its code enforcement to entire dwelling rentals done by absentee landlords. I don't agree with that at all. The city must recognize the huge difference between a homeowner responsibly renting a room in their home in a hosted and supervised setting and the practice of renting out entire dwellings by out-of-town landlords and speculators. Homeowners who are there on the premises and supervising their guests responsibly are not the problem here. The real estate speculators and greedy entrepreneurs who rent entire properties out in absentia are. They're the ones who cause issues with neighbors and they're the ones you should be going after. Since last July, the City of Orlando has allowed short-term rentals, but only when the owner is also present within the home. I urge the City of Titusville to follow suit and adopt a more sensible policy permitting responsible hosted vacation rentals and to stop harassing fixed-income retirees who are just trying to get by and are causing no trouble to anyone. And I ask you to consider this. I have a neighbor who runs a very loud tractor mower and at least 5 different gas-powered yard tools for a couple of hours, pretty much every single day of the week. Yep, that's 12 hours a week or 48 hours a month. If you'd like to debate the relative adverse effects of this constant and deafening onslaught upon our peaceful little neighborhood versus that of a single car pulling quietly into our driveway and a person entering our home, let's have that conversation. Now, I'm willing to stipulate, yes, we rented Airbnb rooms out. We've said so publicly. It's in the newspaper. I'm not going to argue with that at all. You've seen the ad on Airbnb. The ads have been taken down. We were given a deadline of May 6th to correct the violation. There have been no Airbnb guests in our home since April, and we stopped upon the warning from the city, and the site has been taken down, the listing, and if there's still a listing left up on a French language page somewhere, that's an oversight and a mistake that I didn't know about or hadn't heard about until today. But there are no ads on Airbnb. We've followed your demands, even though we don't agree with the city's position on this. We have complied. We've corrected the violation. And we did have a guest in May. I'm not sure if you were trying to cite us for that because it occurred after the deadline we were given. And document 1 that has been passed to you is a sworn and signed affidavit notarized by our family friend who came and visited with us and was in no way a customer, renter, or a tenant that came as a visit. But I get the impression, since we had another citation come to our door within a couple days of her leaving, that the city was attempting to conclude or charge us with the fact that we had, in fact, taken another Airbnb guest. We have not, nor do we intend to. Finally, in their headlong rush to come after us, your Titusville code enforcement officers have driven numerous times right by the 3 different vehicles that neighbors right on our street park illegally every day on their lawns and across the sidewalks, as your board member who lives on that street also passes daily. Apparently, they chose to ignore these clear and obvious violations over coming after us. And when we took up Airbnb, as you know, there's over 50,000 Floridians who are practicing Airbnb. There are thousands in the county of Brevard. There are hundreds right here in Titusville, and you all know that very well. So I consider this to be unfair, discriminatory, that we're picked out and all the rest are left alone, and that in the other obvious zoning violations like the cars on lawns are ignored so you can go after this more exotic offense. So I leave it to you, but I have corrected the violation, and we don't intend to try to resume Airbnb. So I'd like the matter to be closed.
Question, sir.
Wait a minute. Mr. Daniel, we're not here to provide you information on what the next thing is for Airbnb. Our job
I
here
know
today is to, yes or no, you're in violation of the ordinance. That's what our job is here today.
Correct, but I'm allowed to
Yes, you
state
can,
my
and you did.
beliefs about this.
Yeah, and you did. And your Airbnb came to our notice because somebody made a complaint. That's how we know about it. We have no idea how
No,
many
I'm well
Airbnbs.
aware of that.
We have no idea how many Airbnbs are out there. Does anyone have any questions?
Well, if you click on your phone and look up Airbnb and type in the word Titusville, you'll very quickly get an idea.
That's
It's
not my
hard.
job. I'm not interested in Airbnb, so I don't do
Right.
that. So I don't.
That's why
check
I'm
it.
explaining to you, perhaps some of you don't know, that it's a widespread practice, nor were we expected to consider it to be illegal by Titusville's rules when you can look online and see that hundreds and hundreds of people are doing it right here in this town.
Did you
So-
ever check with the city ordinances to see if it's legal?
No, I didn't. I saw that hundreds and hundreds of people were doing it. So,
No.
yes, I would have made that assumption that you expect a reasonable person to think that it was illegal.
Well, most anything you do in any county, city, or town is there's an ordinance or there's a permit you have to have, so.
Yeah. Like excessive noise, for instance.
The police get those complaints, and we get them if they come before the board.
You got it?
Any questions?
Help me to understand this, please. The violation was a rental of a single-family home, or are we talking about rooms in a single
bedroom.
family?
Not the home.
Single bedroom.
So-
Never the whole. We would never rent our entire dwelling. I don't believe it's right that anyone should for short-term use.
Well, I have to agree with it, unless this was written in error. It says that 28.9 says single-family detached dwelling.
Correct. This is my point. A dwelling is a single detached dwelling is exactly how your language reads. And again, I assert that your city attorney and your city council, whoever's making the rules around here, is reading into that law what they want it to say, what they wish it had said. But as we all know, since 2011, they are banned, they're barred by state law from improving that law to their desire. They have to go by that old law, and that old law doesn't say anything about having a guest in your home.
Well, maybe some of the fellow board members here can educate me on this here, on 28.9 or
Well-
someone.
Airbnb is a new term that's come up in the last how many times? Prior to the law, written of that law. Came in after the writing of that.
My question is, if you have a single-family home and you have some extra rooms in it, you cannot rent it, you cannot rent it out? Am I,
For less than 3 months,
Not short-term,
not short-term.
That's
Less
the
than 3
ordinance.
months.
short-term.
then why didn't it say that instead of being very specific about a detached dwelling?
Would assume because they couldn't foresee
You
this.
can't assume anything.
I would
think that-
agree. The missing words are
that's
any
being
part
asked.
thereof. Had they been in that ordinance, I would surrender gladly.
28.9, anybody read 28.9?
We don't have a
Can
copy.
you
of
put
it.
that
We
up
don't have
on
a
the
copy of it.
screen?
One second.
28.9.
Do you live at the property
Of
in
course,
question?
full-time.
Pass that
We
down
live
to Gina,
in the
please.
property.
Full-time.
Hold up, hold
On
up.
the screen.
One at a time.
Well, fine, pass that down to Gina. She says she don't have one.
Just a minute.
But where did this come from?
That's Titusville City Code.
There it is.
There we go. You live in the property full-time.
Of course.
You never leave the property, even with guests.
Especially with guests. We would never leave the house. I wouldn't even let our guests stand and talk in the driveway. They park in our driveway, they come in quietly. That is no impact virtually whatsoever on the
It
neighborhood.
just seems to me that if the ordinance said that there could be no short-term dwelling, period, I could understand where you would be in violation. But it didn't say that. It says detached dwelling.
Thank you, sir.
And I like to play devil's advocate a lot, when it comes to the things, but it's right here in black and white. It says
I think the
detached
language of the
dwelling.
law is quite clear, and I think Titusville, like other towns, especially since the state of Florida barred towns from updating, because Airbnb came after the law, so they weren't thinking about it at that time. But now they can't change it, so if you can't change it, try to reread it to your benefit. And I find that to be unfair, and I think the simple matter here is legally, we're not in violation.
Well,
So
somebody
you're
correct
saying-
me if I'm wrong, please.
I have a question. So you're saying you do not live in a single-family detached dwelling?
We do,
Okay, then
But we don't.
that's covered under the law here.
but we didn't rent out the entire single. We didn't leave
But
the
it didn't
place and
say,
rent
it
it.
doesn't say entire, you're just putting words in here. Let me just say this. It's like a commercial enterprise. If someone wanted to come and put a hotel next to me with people coming and going, I wouldn't want it in my neighborhood, okay? Not in a residential neighborhood. And to me, that's basically what's going on here, and that's my statement on it.
So if a single-family home is considered a detached dwelling, even if you live in it?
Yes. It's it says a single-family detached dwelling. That means it's not an
It's not an
apartment,
complex.
it's not a
Yeah.
condo.
Yeah.
That's what that means.
It's a
Madam
house.
Chairwoman, I'd like to clarify the city's position.
Okay, you're gonna have to, because I can't hear you. Okay. Go ahead.
when the respondent's completed with his statement, I'd like to have an opportunity for rebuttal.
Okay.
Okay. Any other questions from the board?
So you've never left a renter in your home by themselves?
Not for a minute. We respect our neighborhood. We're not trying to cause any trouble there. And we keep a close eye. And someone driving into your house, driving up to your house and walking in and staying there overnight does not, in my opinion, present a threat or any kind of a disturbance to the neighborhood whatsoever.
One more
unless you have-
question. How many bedrooms are in that house?
We have a 5-bedroom home.
Okay, and you only advertised 3 of them?
We did, and those listings have been now taken down.
What's the zoning in that area?
R1B,
Meaning,
medium density, residential.
so if it was commercial, I'm trying to educate myself here. If it was zoned commercial, then we wouldn't have an issue here, would we? Or it was, if you do both. I think you have such a zoning where you can do both.
Mixed use.
Yeah, mixed use.
But that's not, that's
But it's not mixed use.
that's a subdivision, it's not considered mixed use.
No, I'm just asking, if it was like that, then we wouldn't have an issue, right? Yes or no?
That's
Okay.
not the facts we have.
Excuse me?
That's not the facts we have.
Right, I know, it's zone, yeah, it's not zone mixed use, so we don't have to worry about that right this time.
And the statute doesn't say, like, if you have more than a certain number of bedrooms, or it doesn't say if you don't leave the guests in your house overnight. None of that is relevant, basically.
He brought us 2 definitions of dwellings, though. That's what he entered into evidence, were definitions of dwellings. And I think that that's where you could construe otherwise.
So are you trying to say he doesn't live in a dwelling?
No, I'm trying to say that a bedroom is not necessarily a dwelling. A
Yes.
bedroom does not offer restrooms, a kitchen, an entry, ease and access, a parking facility. A bedroom does not offer the same things as a dwelling does.
So are you saying these people didn't use his kitchen and his bathroom in the other parts of his house?
Not, they
But I
didn't
don't, I
rent
mean,
it.
I'm not interested in all these details.
they
I
had
don't
a
want to sit here and nitpick, but,
Well, that's what this is.
anyway, I wouldn't want a
That's what
commercial
this- the
operation
point of
going
this
on
is.
next door to me in my residential neighborhood.
Yes, ma'am.
Okay, any other questions? Okay, just have a seat, Mr. Daniel.
This gentleman right here. had-
Well, no, wait a minute.
She'd probably wait till the end to rebut.
Maybe not.
Okay, but wait, hold on a second. I just want to ask, what, does this gentleman have anything to do with this?
I don't know who this gentleman is. It's up to the board to determine if any additional witnesses are,
All right, sir, what is your,
to speak at the podium.
My stepson is a law degree. Would he be allowed to address the board?
Is it to provide factual information?
Maybe a clarification on the definition of dwelling.
No. If you have factual information to offer, then that would be relevant.
Yes and no.
Are you a lawyer?
I'm not a lawyer. I'm a graduate of law school.
I'm sorry.
I graduated law school 2 years ago,
Okay.
but I'm not a lawyer. I haven't passed the bar.
you got to speak up here at the podium. But only to address what,
To answer your question, I am not a lawyer. I graduated law school about 2 years ago, and I haven't passed the bar yet.
Okay. What's the city's position on having a non-lawyer, or who's a non-licensed lawyer, give an opinion of the city's code?
I would object, but it is up to the board to determine if additional witness testimony is necessary.
I think we've been given a couple definitions of dwelling, and so we can probably decide on our own based on that.
Well, I don't think you've actually been given a definition of dwelling. That's why I was wanting the city attorney to speak up on that issue.
Regarding the evidence that was admitted by the respondent, the first item was a letter from a guest that was staying at their house. That's not something that we were trying to impose a fine or sanction on regarding that 8-night stay. So I do not have any issue with the affidavit that was provided. Item number 2 is it appears to be a portion of the city's code. However, it would apply to the urban mixed-use area, which is not applicable to the subject property. And item number 3 is also property photos of other addresses that are not relevant to the subject. case. Regarding the no specific reference to the dwelling in the code, I'd like to refer back to exhibit number 5 that I submitted during the city's presentation, ordinance number 46-2007. In order to, I'm going to read it to you. The item that was passed by, I don't have all 5 pages for everyone because it's too voluminous. I just want to highlight some parts of it by reading it to you. Because when the city was faced with this case, I needed to research the history of the code section. And so I look at the legislative findings that the city council made in 2007. The date of this ordinance is September 25th, 2007. And I also got the minutes of that meeting where the public came out and spoke in support of this ordinance as something they wanted to protect the residential neighborhoods. The maintenance of the character of residential neighborhoods is a proper purpose of zoning. The city seeks to maintain residential districts that promote the permanent residency of families. Limitations on the rental of single-family detached dwellings serves a substantial government interest in preserving the character and integrity of residential neighborhoods. The city's zoning district regulations are intended to permit only those uses that are expressly provided for under the list of permitted uses and conditional uses for each zoning category. All other uses not expressly provided for as a permitted or conditional use are intended to be prohibited. The City Council finds that the rental of dwellings or other structures for short-term use by visitors and transients is a commercial activity and is inconsistent with the use of zoning districts devoted to non-transient residential use. Tourist, commercial uses, and transient commercial uses are not currently expressly listed as a permitted or conditional use within any zoning district. Florida Statute Section 125.0104 subjects those property owners that rent or lease for consideration any living quarters or accommodation in any rooming house, i.e. any house or other structure used or held out to the public to be a place where living quarters or sleeping accommodations are supplied for pay to transient or permanent guests or tenants for a term of 6 months or less, are exercising a privilege subject to tourist development taxation. I'm going to pause here just to say that's quoting the statutory language, the 6 months there. The next one, the same. Florida Statute Section 212.03 subjects those property owners that rent or lease for consideration any living quarters or accommodation in any rooming house, i.e. any house or other structure used or held out to the public to be a place where living quarters or sleeping accommodations are supplied for pay to transient or permanent guests or tenants for a term of 6 months or less, are exercising a privilege subject to transient rental taxation. It is the intent of the City Council to preserve single-family residential use from encroachment by commercial transient rental activities, clarifying the existing intent of the city code with clear language defining what short-term rental is and affirmatively prohibiting it in certain zoning districts. Now I'm going to pause here to say that yes, the City Council did clearly say what short-term is, and there's 2 more pages of this, and I could either pause here or continue to read it all, but I hardly ever see an ordinance by the City Council that has 4 pages of legislative findings. This is an example of something that the City Council has expressly said why they're doing something. The code section 28-9 is very short. It very clearly says what short-term means. It says 3 months and 1 day is okay. 3 months is not. 3 months and 1 day is okay. Less than that is a violation of our city code. There is one specific whereas that I'll read, and then I'll be done with the recitals. The City Council has difficulty in determining what the bright line distinction between long-term tenancy and short-term tenancy is. And the City Council, therefore, to the extent it may err, determines to err in favor of according residents as much freedom as reasonably possible to make use of their property by setting the bright line distinction between long-term tenancy and short-term tenancy as 3 months. City Council finds that vacation or short-term rental uses are inconsistent with the maintenance and perpetuation of the primarily low-density residential character of the city, in that vacation or short-term rental uses are not truly residential in character, but are transient commercial uses. It was very clear that these specific zoning categories where single-family homes are, that specifically includes R1B, you're not allowed to have people rent your room for less than 3 months. I'd be happy to discuss this more, but I've talked to the city manager, I've talked to the planning department, I've talked to the building official, and everyone across the board agrees with the interpretation that I've provided to you here today.
You're reading minutes from the city council meeting?
I haven't got there yet.
Because my biggest issue, though, is that was very specific, and it very well makes sense for just a room. But that is completely non-specific, and this is the only law or rule that we are to consider here today. Yes, this is the one and only rule that we are asking to find compliance or non-compliance with. And it doesn't have the specificity of the bedrooms, the bathrooms.
But it also doesn't say entire. So that's an interpretation that this board is going to make. If you say that he can rent out one room, if he has 18 rooms and rents out 17 of them, is that okay? Because that would essentially be what you're saying.
Personally, it would need to say entire. For me, it would need to say entire, because as a realtor, a detached dwelling is an entire structure. It's the entire structure, that everything, you consider everything as the dwelling. So but we are only to consider 28.9 because that's the code, right?
You can also consider the legislative history of the code that created this policy, which is what I've been reading to you, which is in this ordinance.
So in 28-9, it gets to be more specific, or
No,
this was adopted
28-9,
based
that's
on?
the entire code that follows this 5-page ordinance of 4 pages of recitals.
But the ordinance, we can't actually, you can't cite them based on the ordinance.
We're citing them based on the code, and the code was created based on the legislative findings in the ordinance.
Does the city have any proof that he vacates the dwelling when he rents it out?
I don't think that's the subject of
That's not
the question that we're talking
That's
about.
not the question at this point. The question is he
Well,
involved?
I would think that if I was left in a home by myself without the owner there, I would feel like I'd rented an entire dwelling. And me personally, I have an issue saying that an entire dwelling is rented out when it's just a bedroom, based on the verbiage I'm reading. So it's important to me whether they vacate and someone feels like they have the entire dwelling, or whether they feel like they're limited to a bedroom and a bathroom and that's that.
As I've previously stated the city's position, we did not find that that was a necessary component of evidence to prove to you. So no, we did not research that, and no, I don't have that to show you that they vacated. Are there any other questions for the city? Thank you.
Can the code board attorney please advise us?
Well, all I can tell you is that the city presented the evidence of what the code says. The code is what you need to make your determination on. Essentially, the respondent has acknowledged that they are renting in violation of the code provision, but their argument is that your code doesn't say
It's not specific.
it has to rent out a room in order to be a violation. I think that's a legal interpretation to make. To me, it does not say that it has to be the entire single-family dwelling that is rented in order to violate the code. Doesn't say that, but I understand your position that it doesn't say otherwise.
And even if what we did here today is decide that it doesn't violate the code, that doesn't mean that we've given license for Airbnb to move in. All it means is that maybe the city would like to look at the way their code reads and make it more specific.
Well,
That's not, I mean, you're going way out
If you make
there.
a change, you lose your grandfather status, so.
You're going way out there. We're here just to determine if they're in violation or not. We're not here to determine what the city needs to do with their codes because like I said, I personally feel that the code is correct. And I'm not gonna sit here and nitpick with semantics and split words and say
That's
a
what
room
the career
or all
of
this
law
stuff.
details.
But, because I feel that it is a I personally feel that within a residential neighborhood, that it shouldn't have to be spelled out like that. A residential neighborhood is not a commercial entity. Would you, if your neighbor rented out his garage to a mechanic to fix cars in there, would you say, well, he's just renting out the garage and not the whole dwelling? Would that be an issue?
Well, if you
So,
rented it for 3 months and 1 day in a residential neighborhood, it'd be illegal, wouldn't it?
To run,
Excuse me?
not as a commercial garage in a
No,
residential
I'm not talking about a garage. You say you didn't want it in a residential neighborhood.
I know what I said, a commercial garage in your residential neighborhood. If you're renting it out to a mechanic to fix cars or something, but,
I'm not talking about garages.
Yeah.
I'm talking about the
but
3
anyway,
bedrooms.
I'm basically ready to rule if everyone else is, or to make a motion.
You gotta make a motion. You gonna make it, Gina?
I'm gonna try, because this one, it doesn't, I need to ask the attorney a question. Now, he says that he's not planning to continue following this law or whatever.
Well, I think you find them in violation or not in violation, give them a time period to comply, and then that would give the city the time to verify whether they've taken it all down and ceased
Okay.
advertising it.
Okay, all right, let me make a stab at this. I move that the board issue the following findings of fact and conclusions of law in this case. The respondent is the owner of the property located at, what's the address here? At 1340 Santa Cruz Avenue, Titusville, Florida. The respondent was given proper notice of code violations found by the code enforcement officer and was given a reasonable time to comply before the case was brought before the board. The respondent was given proper notice of this hearing. The respondent or a representative did appear at today's hearing. The evidence and testimony presented show that the respondent, he was in violation, but, see, this is where it gets hairy. But he was in violation at, on the date of the notice, and he was in violation of, you have the printout copy. Okay. Is in violation of section 28-9 by reason of using a short-term rental of a single-family dwelling within a residential neighborhood. The respondent shall be given until June 11th to bring all violations into compliance. It shall be the respondent's responsibility to immediately notify the code enforcement officer when the compliance is achieved so that the officer can inspect and confirm the compliance. If compliance is not achieved by this date, a subsequent compliance hearing will be held and a fine in the amount of $100 per day may be imposed for each and every day any of the violations continue past the compliance date. In setting the proposed fine, the board considers the gravity of the violations, any actions taken by the respondent to correct the violations, and any previous code violations by this respondent. The city's costs of prosecution are imposed in the amount of $134.21.
Have a second? All right, there's no second, Nelson.
Gotta get a new motion.
All right, make another motion.
I move that the board issue the following findings of facts and conclusions of law in this case. The respondent is the owner of the property located at 1340 Santa Cruz Avenue, Titusville, Florida. That respondent was given proper notice of code violations found by the code enforcement officer, was given a reasonable period to comply before this case was brought before the board. The respondent was given proper notice of this hearing. That respondent did appear at today's hearing. The evidence and testimony presented show that the respondent did not bring the property into compliance by the date set forth in the notice, and the property is in violation of the following code provisions. Section 28-9, by reason of short-term rental of single-family dwellings. I can't give a compliance date because I don't find them not in compliance.
Then you're not finding them in violation.
Do we have a structure for finding that they're in compliance?
You would just say, I move to find respondents not in violation.
Okay, then that is my motion. I move to find the,
Okay, wait a minute, but are you saying they're not in violation as of now,
yes.
not as of when the initial ordinance, I mean, when the
Well, yeah,
initial
because
inspection?
I thought I needed to address up to this date, but from this date forward, I don't think that there is a non-compliance violation.
Forgive me
Okay.
for speaking for you, Ashley, but
Okay.
I think the
Yeah.
reason what you're saying, and maybe I can say it maybe a little bit more authoritatively, we find the defendant not in violation of ordinance 28.9. Basically, because 28.9 does not say anything about what they did.
All right, well, so
Now,
the motion that was made, I think we need clarification from the motion maker. Are you intending to say that you don't think there was a violation of the code at all? Or you agree that there was a violation, but now they have brought it into compliance and no fine shall be imposed?
I do not believe their practice violates our city code.
Okay, so I need you to make a new motion.
Okay, I move that the, in case 19-28, that their current practice does not violate our city code.
and if you need a second, I second.
Any discussion? We're gonna have, all right, roll call vote, please.
Vice Chairman Beckles?
No.
Member Edens?
Yes.
Member Grant?
Yes.
Chairman Bell?
No.
We have-
I
he
mean,
gets to
Larry,
vote.
Not even sworn in.
you,
Never sworn in.
If he gets
We
to
didn't-
vote,
When was he sworn?
we didn't swear him in. I
not even
forgot, he's a
sworn
new
in.
member, he's not sworn in, he can't vote.
He's not,
he hasn't been sworn in?
No,
no.
he can't vote. I didn't think about him being new. Was he sworn in by city council? No, I thought he was. Well, we're at a draw.
Well, an attorney has to
We got a draw.
Can we continue it until next time?
do that, I suppose.
Chelsea, will you, could be comfortable and you can provide us some more information, please, you or Glenn? Can we table it till next month? Because we've got a draw and a vote right now, till we get him sworn in.
Well, there's 2 and 2.
We have a draw.
The motion was to find them in violation. I understand. And it's 2 to 2, so,
The motion was to find him in
In
compliance.
compliance, and so hers didn't pass, which means he is in violation.
no, which means we need a new motion.
It didn't no, her.
All right, Madam Chair, may we have a recess so that the board attorney may speak with the city attorney?
Okay, we're gonna recess for 10 minutes. Is that enough? Yes. Okay, 3:10, they're back here 3:10.
That he was in compliance. No, her motion was that he was in compliance.
No,
All right, everybody back? Megan, you back? Yeah, you're there. All right. In the interim, while we were down, we did swear in Larry Edwards as a member of the Code Board.
Yeah, I'd just like to make a couple of comments, because we did speak with the city attorney as well. The code, neither the code nor the Florida statutes requires a swearing in of code board members. All they need to do is be appointed.
Okay.
So he has been appointed, you've all been appointed. The swearing in is mostly a ceremonial duty.
Well, then we had a little ceremony. All right. So now, Madam Attorney, do we need to go back and start all over again?
No, I think that you need to recall the vote,
last-
the last motion.
Okay.
The motion of a finding of no violation. Just call the roll, and our new board member may vote.
Is that agreeable? All right, roll call vote.
Vice Chairman Beckles?
Wait a minute, hold on, wait a minute, what?
Well, do we go back to Gina's, or do we, Ashley, or do we go back to Gina?
No, we go back to Ashley.
Because Gina wasn't
No,
second,
hers was never second. We go back to
Oh, but
Ashley.
he could second.
but he may get a second. I'm
What do you
asking
wanna
a
do?
question, I don't know. Where do we go?
Well, that's probably correct.
I'm a devil's advocate, you know.
You're a devil's
Yes.
advocate, you. Yeah.
But
City
she never,
attorney,
there was never a second on hers.
do you agree? All right.
All right, let's go back to,
The original motion was to find in violation, impose a $100 a day fine with a compliance date of June 11, and imposing costs in the amount of $134.21 with all of the requisite findings of fact.
do I have a second? Still don't have a second. So then let's go back to Ashley's.
Okay, and my motion is that in case 19-28, there is no violation. Sorry. In case number 19-28, there is no violation of the city code.
Second.
Okay, motion by Ashley, second by Ariel. Any discussion? Roll call vote, roll call vote, please.
Vice Chairman Beckles?
You are supposed to do, I'm not supposed to always be the same one. It's supposed to change all the time, but my vote is still no.
Member Edens?
Yes.
Member Grant?
Yes.
Alternate Member Edwards?
Yes.
Chairman Bell?
No. Motion carried. He's found in non-violation, he's found in,
To be not in violation.
okay. Mr. Daniel has been found in not violation. Now what?
Move on to the next matter, if there is another
Go to
matter.
the next case then.
The next case on the agenda is 19-30 for the property located at 2280 Beechwood Court. And the city has found that this property is in violation, or I'm sorry, is in compliance and withdraws this case. Thank you.
Okay, can I ask something? So this means that Mr. Daniel, Mr. Mazzini can still rent their bedrooms out? We're not in violation of the ordinance of the City of Titusville?
My interpretation of today's activities is that the city has not presented evidence substantial enough to prove that there's been a violation of Section 28-9. The city will reevaluate this code, and you may see a case on this in the future, but just as with any code case, we don't know when or how they will come forward.
Okay.
Plus, the city also has the ability to appeal within 30 days, if it so chooses.
Okay, all right, thank you. Any other? Okay. Board Attorney's report?
No report.
City Attorney's report?
I would like to just add, as the board attorney stated, that the city does preserve its right to appeal the case.
Okay. Code Enforcement Manager's report? No meeting in July? Oh, good, thank you.
Really? Really? We always do that? I thought we only
No,
had.
he's trying to get it where we have at least 1 month off during the summer.
Oh, really? Bless you. Okay.
Chairman's report, I have no report. Board members report, any of y'all have anything? All right, meeting is adjourned.